Well, welcome back from afternoon tea, everybody. Can I just say, it's been an incredible day of conversation. And for me, as someone who likes to think of themselves as relatively young or perhaps quickly ageing, in sometimes I think what feels like dog years, it's really nice to hear around the room the experience of decades of advocacy, but also to hear the voices of our emerging young leaders in our sector. And certainly it's a privilege and an honour to be in a space where we can see that the future of advocacy is bright, one that will change, but will always need a place in society, I think, and we've got some great young leaders coming through. I would like to refer to myself as one of them, but as someone who's approaching 40, I'm not sure when that privilege stops. But can I say some of the content today may have raised issues or concerns for individuals that are part of the audience today. And I just want to take a moment that if it is the case that any issues or concerns have arisen for you personally, that you can indeed contact Lifeline on 13 11 14 for confidential advice and support if you need it. And certainly, I look forward to further robust discussions. But just as an announcement, I wanted to let advocates know that DARU has some funding from the Victorian State Government to support advocates with the Royal Commission process. So thinking about what measures you as advocates might need during this process is a good opportunity to use the postcards on your table to put down some ideas and thoughts about what you think DARU could do best to assist you as advocates to continue the important work that you do. I'd like to hire an advocacy agency to find me a husband if there's any takers for that job. Competition is rather stiff, but the applications are still open. But with that in mind, we'll move to not talking about my lack of husbands, but we'll talk about this afternoon further NDIS work. And indeed, this afternoon's panel is about appealing NDIS decisions. It includes taking cases to the Administrative Appeals Tribunal. What do advocates need to know about this process to get the outcome that their client needs and indeed their client wants and deserves? I'll introduce the facilitator of this afternoon's panel, Horton, who is an NDIA appeals officer at Action for More Independence and Dignity in Accommodation. Ange steps in for Judy, who unfortunately due to illness cannot be with us today, but I look forward to this afternoon's panel discussion. Over to you, Ange.
Thank you, Wayne. As an NDIS appeals advocate every day, I'm involved in the issues with the NDIS appeals process, both in the internal reviews decisions and with going to the next level of the AAT. And during this session, we'd really like to make this a session for you as advocates to ask that burning question of a couple of experts. So with that, I'd like to welcome Tim and Darren up to the stage. So we've got Tim Noonan, who's a lawyer and economic in social rights reform program at Victorian Legal Aid, and Dr. Darren O'Donovan, who's a senior lecturer and director of engagement at Trobe Law School. So to kick off, I'd just like you guys to just spend a couple of moments introducing yourselves, talking about some of the work you do, and then we'll throw it open to questions.
Hi. So I'm before a room of experts. I think both Tim and I were very much want to use Ange. We also want to use the floor. I think it's really important that we as lawyers don't hold out, the idea that courts are incredibly accessible. We need to be, when we talk about the NDIS, we need to be really grounded. I think in terms of what we might try and get out of this session, I think obviously there is the casework, which Tim is driving every day. I'd also highlight the fact that the NDIS Act is being reviewed. And while there's a lot of talk about a service guarantee for participants, question 27 is basically an open call for ideas. And what do we need to put in this law, because it really needs to have a bit of a shock, I think, and a bit of a reorientation. So again, I really am looking forward to learning from you, even though I'm sitting up here, which makes me uncomfortable. Tim.
Thanks, Darren, and thanks, Ange. I'm very much coming at this from the same angle, sitting here before a room of people with incredible experience in working with a lot more participants than I will ever be able to work with as a lawyer, in a lot more cases as they come up, and at a lot earlier stage, often a lot closer to the point of crisis for many participants than where the case is at by the time lawyers come in, if indeed they can come in. It's now a situation where we're just passing the 5-year point of reviews under the NDIS. We had the first AAT decision that was published 5 years ago in mid-2014. We're still at a stage where we have a lot of big questions, unfortunately, that are unresolved, or where there is tension about how this review system works. The AAT is big, the NDIS is big, and within that space there's often a lot of room for tension and room for really, really complex issues to arise, even where they're hidden in broad daylight. With that in mind, we're very conscious of the fact that for advocates, it's often at that very first point in the matter where these sorts of issues can start to raise their head, or where they can come from. And so with that as our background, we'd like to take this as an opportunity to answer, give as much context and field as much as we can to try and build that understanding of how these things work, and try and make room to go forwards however we can for as many of the participants as we can.
Yeah, and I think there should be there are some unifying themes, between disability support pension, between any decision affecting people with disability. I think one thing that always comes through when I'm meeting people is the paper chase, the evidence threshold, the onus put on people. So obviously we had Gillian Wilkes from Social Security Rights Victoria, and I think earlier, and when we talk about disability support pension, again and again, the role of advocates that's irreplaceable is supporting people to present evidence in really complex statutory frameworks. And I think unless we're supporting people to narrate their reality, all the data about the NDIS, which gets lots of funding, it's sliced and diced and visualized, we're only collating error, we're only collating the people who could speak up and represent their experience in the right language. And if it's been 5 years, the entire sector had to turn on a dime and present what used to be a language of need, present it in terms of outcome, to talk about permanence, to talk about all those legal terms that don't align with how doctors' reports have been written. And just that reality of trying to hit the language and the word games is devastating for people. And I think if I want to rile up the room, I think, it's a published claim by the agency that the average, the median time to take an access decision under the scheme is 2 days. Now, how do you get to that figure? You get to that figure by talking about actionable records. So when the person gets the information to us, we take 2 days. Who is the clearinghouse for all the information? The room. So when we talk about the underspend, and when we talk about an underspend, we need to reflect that that's devastating for society, because every dollar in the NDIS, it's not necessarily like traditional welfare payment. That is investment. That's like not building a bridge Politicians need to understand that an underspend is missed opportunity. And when we look at that and accountability for that, a lot of language about, the records weren't great. But what you'll also find is high levels of people who withdrew, who declined to get into the scheme, and lots of people who are stuck between initial contact with the agency and that magical moment when the record is actionable. And there's no one funding the most important interface of all, which is the evidence interface, which is the reports, the gathering, the language framing, all of that. When we don't fund advocacy, it's not that we're not funding people who can argue. We're actually damaging the scheme because you won't get quality decisions unless you're just replicating advantage. Rant over. I'm just trying to rev it up, maybe.
Okay, so I have a list of questions here, but I would invite anyone to stick their hand up to ask a question at any point. We've got some roving mics. But perhaps if we kick off with one of my questions, which is, when can someone go to the tribunal? How does the tribunal resolve a dispute? And what is expected of participants?
Thank you. There's a whole range of situations where a person can end up at the Administrative Appeals Tribunal in relation to an NDIS decision. The most common two that we tend to see are the circumstances where a person's been refused access to the scheme, whether that's under the early intervention pathway or in accordance with the disability requirements, or where they're dissatisfied with the plan that they've received. That's where my experience lies in dealing with more so with those cases. And they wish to not challenge, but have reviewed the decision that the agency's made about what's going into their plan. In order to get to the Administrative Appeals Tribunal stage, and this is where a lot of the difficulty does arise and where a lot of the current tension is, a person needs to have that decision, which is a reviewable decision under the NDIS law, reviewed by an internal reviewer. There's no fixed time for how long that decision can take to be made. We had some developments in the law over the course of the last year that suggested there might be a sort of deemed decision where that internal review decision could be said to have been made if it wasn't made within a reasonable amount of time. But it looks like, from the way the case law is now going and the way the tribunals are treating the decisions, we're back to the point where you need that internal review decision to be made, and you need to have that and to be able to take it to the AAT to be reviewed. Once it's at the AAT in these sorts of cases, the AAT isn't a court, but as many of you I'm sure will know, it resembles one in a lot of ways. The NDIA is legally represented, whether that's by lawyers in-house at the NDIA or a private law firm acting on their behalf. The general course of a case is that there'll be conferences early on to see if a matter can be resolved. And if the matters can't be resolved, then it will go to a hearing before a member of the tribunal. We can see from the data that the AAT has published, not many of these cases go to final hearings. Something like 3.5% of the reviews that got taken to the AAT in 2017, 2018 got a final published decision. So there's a lot that happens along the way to that end point. But that's the broad run. People have the internal review decision, they apply for a review, that conference and conciliation process happens, there's a lot of evidence gathering, and then it may resolve, it may go to a hearing.
Yeah. And so, I mean, in terms of when people go down that road, you've got a 96.5% settlement rate. In my experience, Tim has a lot more diverse experience, but very often settlements issue incredibly late because of the process of escalating it and getting approval within the agency. What happens with the 3.5? So how has it been going? That's 56 decisions. I write a little digest where I summarise them all. Lovely work that is. But in terms of the actual outcome, 48% are successful. 52-48 of that 56. Now, what's really interesting to me is if you broke that down and you said how many planning decisions are changed, I think it would be I think it would be high, because most firms, in my experience, most of those are in the access area. So interestingly, I used to be able to sit here a year ago and tell you what was the broad outcome of the settlements. So the 1,200 settlements. The last known figure on the settlements was 42% were positive, increased the funds or gave access. That is now behind a black box. We can no longer access the legal reality of the system. So when you open up the quarterly report, they will only give the outcome for the 56, not the 1,200. And that is a change from a year ago. And I would make the comment, Tim's comments are important around people under the law. There was a provision in the Act that said you're entitled to a decision in a reasonably practicable period of time. The tribunal took steps to enforce that. So when it got over 8 months, 9 months into the end of the plan, it would throw the circuit breaker, take the matter up. What Tim is referring to there is we lost that right recently when the deputy president of the tribunal found there were basically 5 words missing in the Act, in section 25, that we need. Basically, the Act is poorly written, there's a drafting flaw. So I'm sitting here today and I'm hearing promises about a service guarantee in 2020, and we're missing 5 words to take the most catastrophic delays off the system. And Mary Mallet and various other people with Disability Australia, they were in the Parliament last week talking to a streamlining governance bill for the NDIS, an obscure piece of legislation which is really about just making it easier for the government. But no one, that was the first piece of legislation that they rushed through. No one rushed through the 5 words for the delay, the cases of delay. And I think that is a very disappointing message in the early days of this Parliament, because I had people emailing me, which is how desperate you have to be to email a law lecturer. And they were emailing me saying, I've been waiting 9-10 months. I thought that they would take it up. I heard that they would take it up, and they didn't know the VLA cases, LQTF, KRBG, which changed that situation. And watching people in the middle of an election when it was retail time, and no one was talking about that people, we're talking about all these new things, and something that was there as a backstop has gone. So again, I suppose I'll take some of Tim's comments and turn them into a policy agenda.
So I've just got a question here at the front. While that's coming, so what's the point of taking a case to the AAT now if the plan might be finished by the time you get there? Is there a point?
Big question. I'm going to throw that because Tim just pled this case.
That's a huge question. We don't have the definitive answer to that yet, but it's probably yes, there is a point. There is tension in this area of law at the moment. A few years ago, we had several decisions from the tribunal that looked at what the tribunal's power, when it was reviewing one of these decisions, and here particularly we're looking at the what goes into a plan sort of decision, when a new plan had come after that. And it said it had this very broad conceptual power to move forwards, to really take the idea that Parliament has given it the power to do reviews of these plans, and that as a result it must have been intended to be able to give effect to that power and make plans that just go forwards even when there'd been a subsequent plan coming in. That has never really been tested beyond the tribunal space in those words. It hasn't undergone the sort of rigorous testing that the federal court, when it conducts an even higher level and a more scrupulous review of what the AAT is doing, does to try and give meaning to those words and to try and set out very clearly what it is the AAT can do. With that said though, there are a lot of options when a person takes a case to the AAT. When it does go to hearing, when it is looking at that really, really blunt question of what are the AAT's powers in reviewing a decision, those sorts of tricky questions come up. When a person's at the conferencing stage before that, before you get there, our professional experience certainly is that there is a lot of room to manoeuvre in terms of trying to reach outcomes that work, but that is contingent on the conference process working.
Okay, the question was just here.
I thought the whole purpose of the NDIS was to help people with disability, not to put barriers in front of people with disability. Why isn't it made a lot easier?
Great question. Why isn't it easier?
Well, I think, we have an extraordinary comment from the Deputy President of the Tribunal, Deputy President Forgy. Mm-hmm. In February, she described the process of review as essentially unacceptable. Paragraph 3, KRBG decision, totally bold, saying this is not easy to navigate. You have an Ombudsman and an Audit Office report which effectively found that complete confusion in terms of, is it a change of circumstances? Is it a review? What people have been through is pretty devastating. And I think unless we start from that point, and I look at the review and I look at service guarantee, and I just think you don't get to tell. You don't get, I think the service guarantee is leading, it's all over this. We're going to review the NDIS Act with a focus on participant experience. Participants will tell you what I think the positioning is wrong there in terms of they're coming to us with this service guarantee. I think the sector needs to take back that review and many areas. So in response, I think the review process needs to be torn down. I think magic words, the power of magic words is the dominant experience, and that's really frustrating. It's empowering people like me and Tim. It's not empowering people with disability.
People with disability should be running the NDIS.
Strongly. That's what's people with disability should be running the NDIS. I absolutely agree. We're just electricians. I look at some of these decisions, and if lived experience was in there, you would understand what it means to the person, and that's the heart of every NDIS decision. Is what it means to the person and why it will pay off. That's the core, that's all the law says, really.
Yeah.
And if I can just... sorry.
No, go ahead, Tim.
If I can just build on that, I think we've had some of the 56 decisions that we've had from the AAT have done an incredible job on reflecting on that lived experience and building on it, and that has been a huge part of the decision. And in many ways, the tribunals in some of those decisions have gone to great lengths to talk about that, and in their reasons reflect on what the interface is between the final decision that they have made about the supports or about access to the scheme and the person's lived experience. And I think that really links back to the question the gentleman asked, which is that in the end, often the outcome that people are getting at the end of this review process, which can be horrendous along the way, is often quite validating.
Yeah.
It can be quite an empowering outcome. The tragedy is in the process along the way to get there. It's in the getting buried in the mountain of paperwork that kicks off the proceedings. It's in all these very technical steps with magic words that have to be used to get from A to B to C to get to the very end of this process. So in terms of where is this scheme meant to go, I completely agree. It is meant to help to empower and to recognise the lived experience of people with disability. It can get there in the end, and we've definitely seen it get there in the end, but where it really falls through on many occasions can be in those administrative middle steps.
Yeah, and can I give one example? Because you said lived experience makes a difference, right? So we just had the first appeal about early intervention autism support Okay, so this is long away. Sorry to the questioner. I might just we'll get to the question. Sorry, but I just think this is to give a concrete example of one of the 56. Right, WKZQ and the NDIA. Okay, agency's decision completely set aside. Right. Funding in tens of thousands of dollars more approved by the tribunal. And the fundamental finding was the agency had this mental model. They approached the family with this mental model that autism therapy needs to be done in non-clinical contexts. And it's quite a blunt rule that they, a lot of you will have met these blunt rules that suddenly wobble hopefully when Tim pokes them or when other lawyers poke them. And in that case, the tribunal did a very simple thing. They said, you approached this with a top-down mental model and you disappeared the evidence given by the family. The family were in an established ABA therapy plan that they felt was working for them, that they had 5 medical experts. I mean, who gets outcome right there? Someone who can call on 5 funded medical experts. I mean, that's terrifying in itself. But the point is that a lot of the frustration Tim and I, or a lot of people feel is, we have these decisions. Where's the frontline practice to comply with them? Where's the learning? The NDIS, the policy documents, the last time, they used to always have the AAT decisions in their operational guidelines, haven't done it since early 2018.
Yeah, they haven't been updated.
They haven't really been updated. So transport, all the usual suspects that we might get questions on. A lot of this is about the policy is dating. The policy isn't reacting to the work. So we might take the
next question.
I'm pleased about the review of the Act, long overdue, rather tired about hearing how big it is, how big a job it is when you look at the staffing of it. You're dealing on a daily basis with a lack of capacity, a lack of expertise, and at times a lack of commitment by the frontline staff in the planners and the directors. Now, where is the accountability for the money being spent for the NDIA's legal representation for the AAT hearings? I just want to jump back to when we got the New South Wales Disability Services Act in 1993, worked with it for only a very short period of time where we realised it was flaws. So we got the karma in place to do that. Far too long for 5 years for it only now for that flawed legislation, which was recognised as being flawed as soon as it was read, to be done. But coming back to the accountability of the money that's being wasted on the legal representation, many of the decisions that have gone to the AAT, if they had been referred to David Coyne's complex planning unit, I believe there would have been no need for them to go to an AAT. The first AAT hearing that I was at, the solicitor engaged by the NDIA stated that he was there to negotiate a settlement with me. I informed him with respect that I was not there for that purpose, that there was evidence, actual factual evidence of the man's need, and that was my entire expectation that that need would be met. Now, I referred to the legislation. He was not over his brief or the legislation. He said he would have to go back to the agency for more instructions. Now, we ended up getting exactly what that man needed, but he was a solicitor engaged by the NDIA who had to go back for further instructions because he wasn't across his brief. I'd be very interested to see how many dollars have been spent on the legal representation for the NDIA.
I might take that one. It's probably more appropriate for me. I might just take that one because obviously Tim is an officer of the court and there's some certain professional response. I mean, I would strongly endorse that in terms of why are getting it right first up is so much better than setting it right later. Okay? Centrelink, the agency, I'm seeing a lot of we'll take trouble when trouble comes to us. The frontline decision making is very blunt and it's we'll wait and see what comes to us. And that's part of this era of onus on people that when you pick it up, it falls apart. And the very black and white operational guidelines are at the heart of this in terms of there's a lot of shortcut training documents that need to be published.
There's a lot of reference packages that need to be published, because a big issue here is when do words become figures? Because we eventually have to appeal to turn the figures into words. And to me, we're spending far too much time triaging escalated matters in the tribunal than on being very clear and open about the judgments that are underneath the frontline policy and guidelines. So I know there's comments and huge frustrations about lawyers. I think I made the comment that we're empowered by this system, like that it is, to me, I think there's a lot of the points around the Act. I think the only thing that will reset them is a very clear policy reform agenda. I think things like lengthening the plan would help, giving people the option for that, not recognizing that it needs to be an option, because it's an incredibly intense process to make an NDIS plan and then to be a consumer within that plan. And the legal burden on people, what's expected of people within the scheme in terms of administration is just terrifying. Yeah.
So we've got a question down here.
I think that's a good lead-in for my question, because working as an NDIS appeal support officer, I don't have legal training, and I'm presuming that a lot of the advocates here don't have legal training. We're trying to do NDIS appeals. So in some ways there is a big imbalance of power when it comes to going to the AAT, and it is quite detrimental to our clients. The other thing is that under the AAT, they can only review the decision that was made in the internal review decision. Now, that decision relies on what we put in as the decision under review. And a lot of people who apply for their own reviews do not know the terminology to put in, forget a support that they might have wanted, and by the time you get to the AAT, that cannot be looked at because it wasn't put in the original internal review decision. So is there any point in developing a set clause? So say I want to have an S100 review of supports under section 33 or whatever of the plan, about the supports in the plan rather than being specific, so the whole thing can be looked at the AAT, because it's getting to the point that where people nominate a specific thing that they want reviewed, nothing else will get looked at by the time it gets to the AAT. And the same thing with access. You might be granted access, but then the funding that you get cannot be reviewed till you go through the whole internal review process again. So it's very limiting, and we're not really supported or taught how to fill out these forms correctly. And then we're dealing with lawyers from the NDIA who try to get people to sign things or confuse people by setting up things under section 26 or getting you to sign an agreement that a person with disability has no understanding of, and I as an appeal support officer have trouble understanding, and yet we're not supported to explain this correctly, or the NDIA are approaching people with disability directly and excluding us as the appeal support officer out of the whole process. And so things are being circumvented by not actually talking to the appeal support people that were there to support someone who needed advocacy in the first place.
That's a great question. Tim?
Thank you for the question. There is a lot in there. The big point, I think, if I can paraphrase, you're getting at though, is that there aren't the resources or external support there for advocates assisting people in an area where, as Darren and I have said, there are these magic words, there are these concepts which often don't seem very straightforward and face value, but which actually can make a huge difference a long way down the track. Like, just as you've said, what you ask for at the internal review level. I completely agree. I think that there should be more and better resources available to advocates to help understand what it is that an advocate is assisting a participant doing when they are asking at that internal level, to try and account for those things and to make sure that those issues don't crop up further down the track. I know Victorian Legal Aid is considering a number of ways in which we can support the sector and advocates as a whole in taking taking resources and being able to better understand that process. Part of the difficulty there, though, is that some of those different issues are issues where there is still tension. So where there is still tension in the case law, in how the AAT is treating individual requests, the exercise of different review powers. So exactly what you were talking about there, in their decisions that they publish, let alone in the way that those things are being dealt with at conferences, and the sort of behind the scenes that can't be seen into and which can't be a basis for policy and for us to give that level of, not quite legal advice, but that level of resource that can be used. So it is something that we are paying close attention to. It's something that I know a lot of different agencies and organisations are paying attention to, but it is somewhere where it's only as the map's unfolding, and I agree it is happening too slowly, but it's happening largely at the rate it is, and we have to grapple with that to provide that level of support.
There's a question just here, the lady in the cardigan. And then you're next.
Brianna Lee from People with Disabilities WA. We're seeing a little bit of a disturbing trend in WA of people who have put in an S100 internal review being offered an S48 unscheduled plan review, with the onus then being that you'll withdraw your internal review and we'll go with that unscheduled plan review. The issue there being then that is removing their statutory right to appeal the new plan, having to go through an S100 again before they can actually get to the AAT for a decision. So I'm wondering, have you had any experience around how to handle that? Because the AAT in WA have said that without a notice of decision, they won't consider that unscheduled plan review to be a decision.
I just find some of these leveraging the realities that are presented as realities to people. Oh, it's coming up on your review date, so we'll get to it then. And the confusion between the change of circumstance review versus, the key thing is that you get your internal review to the planning decision in within the 3 months, and then you keep that on foot. I personally think you keep that on foot. In terms of what a change of circumstance form is able to achieve, I just think the whole thing needs to be wrecked. I think we just need to be frank and say we need to. Can anyone point me to where in the design of the NDIS there was ever meant to be an expiry date on plans? That's a convenience for annual reporting on the spending of plans. That's data driving the design of plans. An NDIS plan should be expressed in timeless terms, where it's not an annual plan. It is, you will get 5 sessions per month until we implement a review. For too long, we've been letting the convenience of expiry dates, the convenience of, I think, the computer system, which is described as a minimum viable product by Department of Human Services. I think there's a lot of tail wagging the dog in terms of why is it 1 year? Why can't we manage the transition period where a plan? Why can't it be extended? I just think all of these issues. I think you get your internal review down and you keep it down, because when the tribunal will look at it, they'll look at it.
Yeah.
I'm not going to take the quick option of the unscheduled plan review versus not knowing how long it's going to take for the internal review to actually be processed. So they're put in that horrible position of having to choose, do I try and get it sorted now and maybe still not get the decision I need and have to restart the process, or do I keep waiting until the decision is finally issued? So I guess, is there any scope for us to be arguing, well, you've issued a new plan in response to the internal review, so that has to be considered a decision. Is that something we should be taking to the AAT to get them to be making comment on whether or not that in itself can be considered the decision that's been made by the NDIA?
if I can just say at the very outset, this whole situation is horribly circular. horrifically circular, and I completely understand and can empathise with where you're coming from as someone who is, I imagine, being confronted by a family saying, we're in this situation, what do we do? Because that is the sort of question that, in terms of seeking legal advice, we have had, it is the sort of thing that you would expect to come up in a range of contexts, but exactly that question. They're offering us a thing. You are talking about a participant or a participant's family who are in that situation of crisis. What should I do? Is one of the hardest questions to ever be faced with. From the angle we would take it at, it's that we can only explain what the advantages and disadvantages are, and what the risks, if they were to go down either pathway put before them, could be, versus the advantages that lie within. I completely agree with what Darren said in terms of the risks there, being that they could a person in that situation could quite circularly exclude themselves from having a decision that could be brought before the AAT for review, under the current trend to how the tribunal is looking at these cases. In terms of what do you do in that particular situation, where you have a participant who is saying, or who is in that place, and there is the potential for a plan to come out of that. I don't think the law on that is settled. I don't think that I can honestly give you a firm answer one way or another. I think that is definitely a sort of matter where, if you are presented in that, it may be something you wish to seek legal advice in the context of that matter. All I can say is that it's unresolved, but the trend at the moment that we are seeing definitely tends towards needing a internal review decision to have been made, and that a plan to come out of that process, it would be difficult to see how you would have that internal review decision. That's probably the furthest I can take that.
It would also be interesting to find out whether or not those offers are being made verbally. Yeah, ask them to pop it in writing.
Yes, harden it up.
Yeah.
We've had some success with arguing that the S48, that the plan outcome should be a result of the internal review, and that if they're not happy, a notice of decision should still be issued. But I guess my concern is for people who don't have an advocate involved, who don't know that they should be arguing for that. How do we make sure that they are getting that statutory right to appeal, that they know that that's what they should be doing? Saying, no, I'm not cancelling my internal review. You do my unscheduled plan review, and if I'm not happy, I want a decision. So how do we make sure that everyone else has that knowledge and has that ability and that capability?
Yeah, that's a big thing. There's just Trevor down the front here.
Thanks. Trevor Carroll, Disability Justice Australia. Our agency does NDIS appeal work and obviously work in the AAT as well. Just a couple of observations. First of all, I think it's entirely hypocritical that participants have to abide by time frames by which they need to lodge a request for a review. However, there's no timeline for many of the agency's decisions. That's the first thing. It's hypocritical. Whoever designed that act needs to be taken out and dealt with. Secondly, we read a lot of the decisions by the AAT at our agency, and the Act is underpinned by the principles of the UN Convention on the Rights of Persons with Disabilities. There's a whole section in there about what the rights of people are in terms of the NDIS Act. However, I haven't seen a reviewable decision come from the agency to any of on behalf of any of our clients that actually quotes their human rights. And I haven't seen any of the decisions that have been handed down so far in relation to our clients, or any key ones, that refer to the UN Convention that underpins the whole Act as well. So I'm interested to hear your comments about that. And the last point is that one of the real barriers of this whole Act for participants who get rejected to the scheme under the access request requirements is that there's no Medicare item number for them to get funded for reports.
Yeah.
And many of the specialists hold them over a barrel by charging $600, $2,000, $4,000 to get a report written just to get into the NDIS. Or even to lodge a Section 19 alternative one, but there's no item number. So the medical profession just screw them over. Interested in your comments on those points.
I like those. I mean, first of all, on the UN Convention, you won't be surprised that I see one tribunal member who is continually mentioning the UN Convention, Professor Ron McCullum, the lived experience driving that emphasis on values. So in Parosh, his transport decision, it's there. Now, interestingly, there's a case which I think VLA took, Jesse Taylor, the barrister, took Pavili Pile, which is a bit of I mean, we talk about the UN Convention underpinning the Act. It's in a corner. As legally, the UN Convention is a principle alongside 21 other principles, and the actual core methodology of the Act is more driven by COAG, the National Disability Strategy, as the primary guide on what the values mean. So in Pavili Pile, when it came down to would this support enhanced participation, the UN Convention would have supported that, but the actual domestic documents weren't necessarily aligned to that. So I think a lot of people, when the Act was reviewed by Ernst and Young, 2015, a bit of a missed opportunity, and an awful lot of the sector put in submissions on the principles. The principles are backdrop concepts. That's the blunt truth. And the UN Convention is in Section 3, the principles section. We need to get those values into the main body of the legislation. The second point, which was, you might trigger me. I just want to talk about evidence and how it's structured for access, because this is an important part of the policy, right? So up until you are accepted, you lodge a valid access request. You are helped informally, there's no funding, informally to put your documents together. So if you've got a medical treatment history that's somehow unavailable, that's higgledy-piggledy, that has the classic problem of there's an unexplored treatment option, or the doctor said, manage the condition, things will improve, or lots of that medical language that causes trouble in the access. In order to get that clarified, you're back on the state health system, and there's this evidence overhang, and the stories for young kids. There is entire areas of the NDIS where the underspend reflects an evidence overhang. And until you get that valid request form in, the agency policy is only informal help. Once you are given, you put the valid request form in, you become a prospective participant. And then the agency's policy is triggered. And when you look at the access operational guideline, there's one line in there that talks about, if we ask you to get a report, we will give you support, including financial assistance where appropriate. Now, first of all, how many people do not know that exists? That ability to demand, and also there's this trend where the agency sometimes will the agency ask for it and then fund it? So there's this little evidence tennis that is accompanying the access process, where they like they request a whole lot to lodge a valid request form, that when you're first contacted, give us all you've got, lodge the valid request form, and then when you get in as a prospective participant before the access decision, it's on you to pull down that policy and demand appropriate funding as a prospective participant to clarify any ambiguity in your file. But I have seen no data on that. I've seen no data on the degree to which they are willing to spend to clarify the ambiguity in the doctor's reports for a prospective participant. It'd be a great estimates question. Let's put that one down.
There was a question right at the back. Right at the back. In the middle table. Do you want to just pop your hand up a bit higher? There you go. Thank you.
Thank you. I'm Denise from the Gippsland Disability Advocacy Program based in East Gippsland. Look, my question really, and I'm not sure if it's really appropriate, but it's about the statements fully treated, stabilised and permanent for the disability. I've been working with a number of clients who've got conditions like an ABI from traumatic experiences. They've got very significant needs. They've had extensive periods of treatment, and because the neurologist or the treating doctors have said it's not necessarily permanent or fully treated, they've been denied access and they're in great need. And I have to say, that's both with the disability support pension and with the access to the NDIS. And I guess what I'd just like to comment is I would love to see that there was an ability in both those acts to have something that was, say, for 2 years or 3 years, and then it could be reviewed after that. I don't know if that's a possibility, but particularly with ABI, particularly with mental health issues and physical disabilities that are being treated still.
I think that's an accurate observation of the difficulty that participants, people who are aspiring to become participants in the NDIS, or people who are in but struggling to access particular supports for certain aspects of the conditions that they are looking to have addressed through supports, and people who are trying to access the disability support pension face. Both of them have strict tests, and there is a lot of difficulty, perhaps not so much in how they are being approached by the tribunal when you get up to that level, but particularly by people who are interacting with each of those schemes at lower levels in conflating them completely, getting tests wrong, defining what the degree of permanence that a condition needs to have for NDIS NDIS eligibility with what it needs to have to be assessed as part of a DSP assessment. The criteria for DSP are obviously very different, and I would certainly say are much more specifically framed, and they do have a sort of catch-all in a lot of the provisions that looks at 2 years. It looks at whether the condition's expected to improve within 2 years. A lot of the policy that Centrelink applies looks at 2 years, 2 years and 5 years often as being rough benchmarks for when they will be prepared to say that a condition is fully treated if it won't improve with reasonable treatment in that time frame, and fully stabilised, roughly many people would say in the same terms or with the same practical effect. The NDIS, the way the NDIS legislation looks at it is a lot more broad, I would say, and I think leaves room to try and in many ways, I suppose, give more people access to the NDIS, I would say, than what the DSP framework does. But with that breadth comes ambiguity. And that can be a big problem. Exactly with what you identify there, circumstances where you have a medical professional who's made a remark, more likely than not in a medical context, where they have no idea that a lawyer or a person applying a legal scheme is going to end up looking at it and take a meaning from that. Because, and I'll be the first to say, when doctors and lawyers look at words, we are often looking for totally different things in what they're saying.
Like, I think I'm very worried that the evidence threshold around permanence and treatment is going to make this a North Sydney scheme, a TURAC scheme. I think when we look at CALD, when we look at socioeconomic disadvantage, I wonder, like when we look at the test for, is it likely permanent? The first thing I would hammer there is, in order to be permanent, their suggested treatment has to be likely to remedy the condition. Now, I'm getting angry there, remedy, because it's not enough to manage it. It's not enough to make it move a little progressively. Their option has to remedy it. And always hit on that. The other thing I would say is, in terms of treatment options, the tribunal is taking a very strict approach to if there's an unexplored treatment option, even if you can't afford it, even if it'll endanger, this may be, I'm worried that it may even cover, even if it may endanger your health. In other senses, you need to pursue it. So cases like SWAT, McFarlane, in the tribunal, we see a huge threshold on exploring treatment options, regardless of your financial ability to pay, regardless of its availability. So Deputy President Humphreys has ruled that a treatment is available even if you can't afford it, and even if you're on a hefty waiting list. And I'm afraid that's pretty bad news for those of us seeing people in the health system. And again, obviously, the long history with psychosocial. I think one thing I also want to flag, if we're talking about intersectionality and the dangers of particular cohorts, I do get very worried about women in caring roles. So MHZQ is a recent decision of member Bygrave, where the agency held that because a woman they initially tried to refuse her access because she was caring for her child who had a disability. She had a Facebook page, 2 friends, and had been on a holiday. Luckily, the tribunal turned that one inside out and described it as unacceptably superficial. Basically, that is a very selective way of looking at whether someone is functioning. She had, not to be too dramatic about it, but she had no life. She was pushing herself to care for her daughter, and that was used. I think sometimes people are punished for their resilience when it comes to function. And I think we need to have frank conversations around gender. Particularly, there are some concerning stats around the level of women, because women will be in a caring role. And if you're saying that caring for someone is a sign of function, I was looking at that case thinking, I hope that isn't widespread. I really hope that isn't widespread on the front line. That assumption that someone is managing to care for a daughter, and has a Facebook page, and somehow that's an acceptable amount of self-management.
We've probably got time for 1 or 2 more questions. There's a couple over here. Oh, yep, sorry, there's another one down the back.
Hi, Kathy from Gippsland Disability Advocacy. In terms of permanence with mental health in access, I was actually wondering about whether you can use medication as the support. So in the Act where it mentions that the functioning is without support, equipment, blah, 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 with mental health, the medication is the support. And I'm wondering if you can actually do that, because without the medication, the mental health symptoms re-emerge.
Tim?
I think that's a tricky one, because there again, it will always vary on a case-to-case basis, and we're really starting to drill into the facts of what a particular person's circumstances are. Can I say that the way that the NDIS, the legislation was drafted, the background to the NDIS, was prepared in an environment, as I understand it, where consideration of mental health really came in at quite a late stage, and where the way that some of the concepts that the Act grapples with aren't well calibrated to the way that people's lived experience of mental health often is in their day-to-day life.
Can I just say one trick or one tip I would always say is the agency always wants to make it about daily functioning. So when you wake up, how do you go? It's a really grounded conversation. I like to come back to roles. How are you going? How are you looking in terms of your career? Are you interacting safely with the community? The thing about mental health is it's ups and downs. The Act recognises that in a kind of saving provision. But I think when you're trying to get someone with psychosocial disability into the scheme, I think it's really important to come back to big picture. This person is not capable of fulfilling roles over the course of a year. Because an awful lot of it is about when you get up, and I hate that daily frame, because I always think of the person who, if they have a justice event where they're arrested or something, or they have some sort of safety concern, they're not going to be able to cope with that event, that episodic event that's going to predictably happen to them. So I just think that we're very often drawn into the actual conversation around access is just not adapted to capture that episodic, fluctuating crisis events, predictable crisis events for people, and people get failed by the assessment tool then.
And just if I could add on to the end of that, when it is looking at a person and how, in terms of those big picture roles, and everything that kind of sits between those two endpoints, will be able to cope in situations, will be able to take advantage of opportunities that are given to them. The way in which they have particular medication, or even if it's not medication, another support that they rely on, will always be particular to their case and what degree of support that person actually gets. And for a person who's dependent for their own health on medication, that can be a person who is responsible for their own medication, is able to cope well with whatever the side effects of their medication are, and is well supported, if I can put it that way, by their medication, all the way to, in each of those areas, at the other end where they struggle to be able to be responsible for their own medication, even if it does assist them, where as a participant they don't derive a benefit from the medication that they're getting. They find that the side effects, in fact, cause them more problems. So I think that one, unfortunately, will always fall on a case-to-case basis.
We've probably got time for one more question. Sorry, just one.
Okay, so we've gotten to the tribunal and it's been 10 months. The client actually ran out of funding 6 months in and has had to go backwards because they were doing so much for this family. The person had gone forward in a really positive way. Once they lost that funding, they had to go backwards, and the person has got majorly complex needs. Is there a loophole to be able to get more funding while you're going through the tribunal? Otherwise, the family are going to feel like giving up just to get some funding to help their child.
This is one of the areas where, as I said before, there are areas where there are tension. This is one of them. At a whole bunch of stages along the way in the NDIS review experience, if I can put it that way, over the last 5 years, there have been different options put forward by the NDIA as a way to achieve this. First, they were talking about something called a Section 26 review, which was to enable the NDIA to vary a plan of their own initiative. There was a decision from the tribunal in Sydney that said that's not a possibility. Following that, the approach then became to use the tribunal's power to give approval to settlements, Section 42C of the AAT Act, to do that. Recently, the tribunal has handed down a decision saying you can't do that either. The latest suggestion we've had from the tribunal is to use a different power, which is to send the decision back to the NDIA for them to reconsider it and then make a new decision and bring it back to the tribunal using a power that the AAT Act gives to try and achieve that end goal. I can't give you a certain answer on whether any or all of those options are valid. They all certainly from a point of view unacceptably rely on the NDIA agreeing to do it and then honouring that agreement really without any power of the AAT to supervise that process. In terms of is there a way that a participant can force the NDIA to give them more supports on an ongoing basis while that review is on foot? I can't honestly sit here and tell you that there is a certain way to achieve that goal. What I can tell you is that there are decisions out there that reflect the fact that the NDIA does seem to be willing to make some provision in terms of adding money in or in terms of extending plan review dates to make that a reality, but that within the last month, within the last fortnight even, we've seen one of the ways that they've been doing that be shot down by the tribunal and another way suggested. Where that's going, I'm sorry, I can't give you an answer.
And I think we're nearly at the end. I mean, I just want to say to everyone in the room, I mean, that's an hour, barely scratched the surface.
fairly.
I think the big message that would come from, not to speak on behalf of VLA, but certainly from myself as a legal academic, there are people who can help you. Like, I would hope that I am one of them. Like, Mary knows me well, and I hope, obviously, my contact details can be circulated at. I'm going to get a wave of work now. But genuinely, I'll be putting in submissions. You can look at what all the issues, like nothing here today said today shocked us, surprised us, or would have me saying, wow, I don't agree with that. I think everyone, there's like unanimity. No lawyer, I think the most devastating thing that we, is there are so many people who've started with, like, when they pick up the NDIS Act and they're lawyers, they're like, this is trouble. This is trouble. And I think everyone in the sector needs to know that. And we all need to, I think the key thing for us is to offer technical knowledge to make sure that all your ideas don't get patronized and get implemented and get turned into legal language. And people with disability have legal power too. And just on a happy story, right? The Birchall swallowing decision, which was a major win, where the agency's entire approach to the boundary between health and the NDIS got redrawn. I just want to mention the fact that they need to listen to advocates, because Jim Simpson, who is a lawyer but also an advocate with the Council of Intellectual Disability, Jim sent me an email in 2016 and he said, this is wrong. This is wrong. And I have the email. I opened it as soon as I saw Birchall, which was a fantastic for the swallowing supports. And I just looked at it and he knew 3 years ago. So I know that when we see law appearing, it's disempowering. You guys have powerful truth as well. Don't be thinking that lawyers, very often they turn to law because they're actually under pressure. So maybe that's a bit of optimism that we sort of carry forward from today. And certainly law is just a tool. Use us.
Thanks for finishing on that end of optimism. Thank you, Darren and Tim. Good.
Thanks again to both our panellists this afternoon. I was wondering whether I could indulge with just one final observation. I'm not sure, as somebody who is a fierce supporter of the NDIS, we ever imagined that we would have a plethora of lawyers champing at the bit to defend the scheme in the way that it needs to be defended from a legal perspective. I'm not sure as advocates we ever envisaged that. I certainly didn't. And then I thought to myself, if I could appoint a lawyer to represent me if ever the need arose, I think I'd appoint Judge Judy and just call baloney. And I think I'm with you, Russell. I think this morning you spoke so eloquently by saying we need to call it bullshit. We need to cut the bullshit in a lot of different spaces to ensure that what we do every day impacts the lives and opportunities of people with disability. And I wouldn't be standing here, and indeed what I would do as a career, and I've reflected this at a conference last week, if I chose the career path of the careers advisors as a young adult that I was advised by, you know what I'd be? I'd be a hairdresser, because there are a lot of people like me in that profession. Now, there are not, although stereotypically it might be the case, there's no data that supports that. There's no S100 review for me to do of the Hairdressing Association to ensure that I can get a review of the reviewable decision. Let me say that again, the review of the reviewable decision. But indeed, I'm standing here because I chose to use my voice for a very important reason. That was because what I saw when I would do my work around Australia and indeed around in other parts of the world was that for far too long people with disability were told to be silent. Indeed, there is nothing different, special or unusual or unique about me. When all's said and done, today, I want you to know that I'm simply just the same as you. And indeed, all the people that we have the privilege to work with want is the same opportunity to access all the community has to offer. in the same way that you and I have come to expect that as a right, people with disability are in the new paradigm demanding equal rights, and that is a good thing. I'm very proud to be... Thank you for that spontaneous applause. I felt a little like Ellen. No, but it's true. It's true, because when you give voice to people who for too long have been silenced, and when you as a country are brave enough to shine a light on the darkest parts of your community and respond, and when we have members of our government, both nationally and locally, supporting the work that we do, we are in a good space going forward, and I'm thankful for that. I wanted to close today with a letter that I received just recently, because this morning I said that you should never underestimate both the smallest and largest acts of advocacy. And regularly I get people writing to me after events, with constructive feedback. They'll be like, Wayne, your hair was shit, didn't like what you were wearing, what you said about the food wasn't great, I'm gluten intolerant. But I often get really delightful letters and stories from people, and I just wanted to take this opportunity in closing today to give you a little story to ignite and motivate you as you go about your important work. The letter reads, Dear Wayne, it was a real pleasure to meet you at the CASE conference, the Canadian Association of Supported Employment conference in Montreal recently. During the gala dinner, I wanted to reflect on a single question you asked me that I did not answer. Your question to me was, what changed my attitude towards myself and towards others? I remarked to you that my school had named an award after me. And when my friend Tony told me this, I thought, shit, no one's named anything after me. What have I been doing all this time? Where's my street? Where's my award? Where's my roundabout? But Tony goes on to say, this award was first awarded to me in 1984 and then given many times during the last 35 years, not each year, just on occasions when the teachers felt there was a student who should receive it to honour a student who faced major physical, linguistic or social, economic or emotional challenges while showing courage, perseverance, motivation, integrity, participation, surpassing limits, achieving excellence and exceeding expectation. And Wayne, I believe that's what you do. It made me realise in this moment that my low vision had shaped my character, had shaped my personality, had shaped my strengths. It made me change my attitude towards myself and others. After I finished my university degree and started working, I contacted the school in 1990 to thank them and to offer to make a contribution to the award. I offered to write a message to every winner and each year fly myself or a member of my family back to the school 6 hours away to present the award. I also doubled the bursary from $500 to $1,000 to go with the award. They accepted this offer with enthusiasm in 1990. I have done this every year since, and it's now 2019. This year's winner who will receive the award on June 21 will receive it from my mother, who will attend in my absence. And I was thinking about our conversation and what an important difference this award made for me, this act of kindness and act of advocacy in 1984. When I wrote to the winner, and Tony shared the letter completely in French, and then I said, Tony, look, my French is improving, but it's by no means, I cannot read a page letter. But what Tony says in closing to the winner of the award is that he understood that his disability had become one of his greatest sources of strength, and that it was a shame that other people, unlike him, saw his greatest strength as one of his greatest weaknesses. It became his greatest source of self-confidence. I hope that this award for you, the winner, is also for you a source of ongoing motivation and confidence in you and your ability, as it has been for me and still is for me today in 2019. Tony is now a Senior Executive Officer in Statistics Canada, and with his permission I share that story because it is through advocacy that we create the change that is needed. That small act of advocacy in 1984 resonates today, just as your work today and every day will resonate. I want to thank everybody for being part of the discussion. It has been a privilege to be your MC for the second year for this conference. I get quite moved every year when I attend conferences, and in particular this one, because I think it gives voice to advocates who every day are working alongside and walking alongside people just like me. And without advocates like you, I'd be some shitty hairdresser in some shitty salon giving people shitty haircuts. Instead, what I'm doing, well, I reviewed that decision. I sent it on to a reviewable decision to my career advisor. Instead, what I am doing is saying that people with disability don't always make the right decision. Who can say that? Sometimes we get it right, sometimes we get it wrong. I think what we get right, though, is that we are all, each and every day, deeply committed and invested in ensuring that people with disability are given every opportunity to succeed. If I wasn't given an opportunity to succeed, I wouldn't be standing here today. So I take every success seriously in the hope that it gives voice and a value to other people like me who might have been told that they could be nothing. Everybody can work, everybody can contribute, and it is the work that we do and the conversations that we have had here today that demonstrate that. Delegates, my name is Wayne Herbert. I have been your disabled gay retired drag queen, MC extraordinaire. I hope you have enjoyed my contributions. I certainly have been thrilled to bits to share today with you. Thank you. Thank you to all of our panellists for donating your time and expertise, and I hope to see you next year. Thank you very much. I'm Wayne Herbert.
I've got a few thank yous of my own. So I think you can agree that Wayne has been amazing. Thank you so much. Another round of applause, please. So, a few people I would like to thank. We've had wonderful panelists, facilitators, presenters, guests. You've all been incredibly thought-provoking and had a great impact, all of you. So thank you very much for your contributions today. Thank you to Show Division for running an incredibly complex AV. We make your job harder every year, so thank you for putting up with us. Thank you to the Auslan interpreters and attendant carers. Most importantly, thank you to the VCOS team, Saru, Michelle McCann, and her wonderful student from AMIDA who volunteered today. We appreciate your work very, very much. Thank you so much. Last but not least, our fantastic conference organising committee, Deb Fuster, Melanie Muir, Julie Phillips and Mary Mallet for helping us put together such an amazing program today. Your work has been really, really appreciated. And last but absolutely not least, my beautiful colleagues at Daru, Damien Kavanagh and Natasha Bragg, who have worked incredibly hard over the last few weeks to make all this happen. So thank you very much for being completely unflappable and keeping my head on my shoulders. And we're a great team, and thank you very much. So thank you, everyone. Have a great week. We'll see some of you tomorrow at the workshop and the VicDam Forum. Safe travels home.
Just before, look, I sit on the advisory board, but the work that Daru have put in really needs to be congratulated. I'd like to thank Melissa, I'll give her a hug in a minute, and Natasha, she's hiding. She's hiding. We'll find you, Natasha, but can you give these two women a big round of applause, and their new colleague that I forget about, Damien. Thank you, Melissa. Thank you. Thank you. Oh, sorry. We've got another one. Mary Mallet, there she is down the back. Thank you very much for joining us and bringing your fabulous knowledge. And just because I know that you were disappointed you didn't get chocolates, Dav have bought you some chocolates. So thank you very much. That's it. Thank you.